Okay, so far we're talking about Texas foreclosure, chapter 51. And in chapter 51, there are sections 0, 0, 0, 1 through 0, 0, 11 is what we've covered. 0, 0, 0, 1 covers the definitions, which we've explained. You have to understand some of these terminologies to move forward and to kind of get a better understanding of the definitions. For example, the mortgagee, mortgagor, debtor, trustee, substitute trustee. These were the things we covered over section 51, 300001 definitions. However, we last spoke on 51001 and 510011. So let's get some clarity on that. But just briefly, 51001 states clearly the right to create a lien by special contracted agreement. Let's read it from the chapter title, and then we're going to the definition word verbatim. Texas Property Code Section 51001, effect on other liens, except as provided by Chapter 59. This subtitle does not affect the right to create a lien by special contract or agreement, or a lien that is not treated in the subtitle, including a lien arising under common law, in equity, or under another statute of the state. Section 510011. And this is about defaults arising from delinquent ad valorem taxes. We talked about ad valorem definition. It means ad valued. And if you didn't get a chance to see the video, you could go see it anytime. It's on the list. But what this chapter covers is installment agreements. Notwithstanding any agreement to the contrary, a debtor is not in default under a deed of trust or other contract lien on real property used at the debtor's residence for the delinquent payment of ad valorem taxes if the debtor gave notice to the mortgage servicer of the intent to enter into an installment agreement with the taxing unit under section 33.02 tax code for the payment of taxes at least 10 days before the date the debtor entered into the agreement, and the property is protected from seizure and sale, and the suit may not be filed to collect delinquent tax on the property as provided by section 33.02. So, what is this saying? All right, so let's talk about the power of sale clause. We covered that in our last video, but this time we're going to go a little bit deeper into it. I'm just going to talk about the powers and rules involved by the state that are governed by section 51.002. We're still in chapter 51 of the property code. And we'll start slowly, trying to go down through here because there's a lot of information in between the lines, so to say. But on the screen, you'll see the beginning. I'll speak thoroughly from each section and break it down, and you can read them as I discuss it. But section 51.002 A through D outlines the rules for scheduling and providing notice of non-judicial foreclosure sales. If the first Tuesday of the month, which is the standard foreclosure sale date in the state of Texas and also in Georgia, if that date falls on January 1st or July 4th, the sale must occur on Wednesday instead between 10 a.m. and 4 p.m. To move forward with the sale. The lender or servicer must give at least 21 days notice, and that's either two ways or both. Posting the sale notice at the courthouse door. In Dallas, that's at the George Allen building on the wall, and also filing a notice with the county clerk. And before I go to the third way, which is sending my certified mail, you will notice a lot of times maybe people in other countries are trying to make money. They'll try to sell you these pre-foreclosure leads or lists, not knowing that the states have statutes that say that this information must be public and free. So you're not paying essentially for the leads, you're paying for the service of them getting the information and gathering it. So if you didn't know that and you have time, it'll take you 20 or 30 minutes just to review the list. And if you're trying to document and investigate, of course, it'll take you longer, but this information is public and it's free. So and that's in the state of Texas. I can't speak for other states. I do know Georgia has a lot of similar laws, and this will be probably in California as well because it's non-judicial. So we're talking about the power of sale clause. They're in a deed of trust, which are typically in your non-judicial situations. I can't confirm this is how it is in California and Georgia. I'm just speaking from experience. I have seen auctions take place on the first Tuesday in Georgia. I have seen non-judicial foreclosures in California. So let's move on. Additionally, the mail notice by certified mail to the borrower listed in the servicer on records if natural disaster or similar events close the courthouse or clerk's office, posting and filing can be done within 48 hours after reporting. Now, before we go on a little further, the foreclosure sale must begin at the time listed in the notice or within 3 hours after that time. So remember that. If you're on auction.com and it says it starts at 10 and it doesn't start, they have up until 3 hours to get started. And that's by statutes, okay? Before even sending the 21-day notice of the sale, the servicer is required to mail a separate notice informing the borrower of their default and giving them at least 20 days to cure. So that's 2 notices. In case you were wondering, there's 2 notices right there. It's in the statutes. This notice also must be sent via certified mail. And the day it's sent counts towards the 20-day period, not the day they receive it, while the day the sale notice is given does not. These rules ensure borrowers are given fair warning and opportunity to prevent foreclosure. So just keep in mind that the first Tuesday of the month occurs on July 1st or the 4th. Public sale under subsection A must be held between 10 a.m. and 4 p.m. And you can pretty much read this as yourself because these videos, they can get long. So let's move on to subsection E through G. It outlines the procedural rules for delivering and displaying foreclosure sale notices. Under subsection E, service by certified mail is legally considered complete once the notice is deposited in the U.S. mail. So they don't have to get it. Once the mailman takes it out, it's considered served. They just need a witness saying that it was served. They don't need nobody to read it, just for clarification. Now, just like I said, an affidavit from someone with knowledge of the mailing process serves as a prima facie evidence, and that means presumed valid unless proven otherwise. Prima, Prima, facie, evidence, presumed valid unless proven otherwise that the notice was sent. Now, subsection F through F1 focus on public access to these sale notices, as I mentioned earlier. County clerk must keep notices in a public accessible file during business hours and may dispose of them after the sale date. Additionally, counties are now required to prominently post foreclosure sale notices online without paywalls, that's free, or registration on the designated auction information page. These online posting must also include the date, time, and location of each sale. Pretty clear and dry there on that rule. Subsection G clarifies the timeline. The date of notice is sent count towards the 21-day notice period, but the day of the sale does not. So that's a pretty clear there. Like I said, this is a small paragraph. 51.002 is very small, but there is a lot within that paragraph that real estate professionals go off of. This is how you get your pre-foreclosure leads. You get the list, you start calling these people, working with them. Consultants use this information, investors use this information, you name it. But it's really found in this small section of Property 51. So now let's continue. Subsection H allows a county's commissioner court to designate an alternate public location for foreclosure sales as long as it's reasonably close to the courthouse and equally accessible to the public. This designation must be recorded in the county's real property records and becomes enforceable 90 days after their recording. Importantly, you got to remember this. A properly recorded change in the sale location cannot be used as a legal basis to challenge the validity of a foreclosure. However, when the sales are moved, notices must be posted at the courthouse door to maintain public awareness. So I know a lot of people try to challenge the validity of these foreclosures. That's not one of the ways to do it. Subsection 9. It requires a foreclosure notice to include a bold or underlined statement alerting debtors to assert protection under the Service Members Civil Relief Act. A lot of people need to know this. If they or their spouse are on active military duty, the provision ensures military families are informed of their rights and can delay or defend against foreclosure when applicable. Additionally, the notice must clearly identify the sender's name and address, reinforcing transparency and due process. Okay, so that was a brief discussion over Property Code 51, the beginning section 51001, 510011, 51.0011 talks about the ad valorem tax rules, to where basically, I've done this before in the past. If you get a house, or if you have a house that has a large amount of taxes, you can call the county and work something out. They might give you 3 years, work out a payment plan. The last one I talked to, I want to say a 2-year plan I had worked out. Can't remember exactly. It was a long time ago. But further research showed there is actual tax loans. They have to be governed differently in Texas because a tax deed is different. It's a clean deed. Sometimes they fall under the homestead rules, which are governed by the Constitution in Texas. Texas has a Constitution that kind of overrides a lot of these national, quote unquote, federal guidelines. But the ad valorem tax talks about another thing about that, typically your taxes are included in your mortgage, but this is just the statutes to cover it because it can be any type of security instrument. If you work out something, there's a 10-day timeline. It talked about that, and of course this gives the option of the lender or the funder to pay the taxes to avoid foreclosure, because of course if it's a tax foreclosure, everybody loses. County deeds are pretty much official. Now of course that governs how things are taken care of when you're foreclosing for tax purposes, using the security instrument 51002, which is more what this video is about. It goes into the power of sale clause and the procedures, the notices, how that operates and how that has to be done. It also kind of sheds the light on how real estate professionals get their information, because this information has to be posted publicly by certain guidelines, and you can always challenge the validity of a foreclosure if these guidelines are not followed. But as you've seen in the video, it mentioned change of location of the sale doesn't exactly qualify for challenging the validity of a foreclosure. But these rules, I said it before, these are from the statutes. These are not from some blog or some YouTube, even though this is YouTube. If you're going to do this, whether you're a consultant, real estate professional, always study the statutes. If you're a homeowner, by God, please know this. This is something they're not going to tell you. But we have a long way to go in this series. We're just starting. We covered 51.001, 0011, and 0001, which cover definitions, trustees, etc. So next we'll probably go deeper into I'm not familiar with the next section offhand, but we will go into the trustees, I know, and talk about the things they can do. So if you have any questions, please leave a comment or let me know. I'll be glad to reach out to you.